Thank you. Please be seated. This is CV 18-0361, Rubens v. Rubens. These proceedings are being video and audio recorded and also live streamed for the first time. So we ask counsel to please identify yourselves and your client. And at the beginning of your argument, we also remind you that because they're being live streamed, the proceedings, that anything you say is likely to get picked up by the microphones and so cannot be scrubbed. It'll just be out there, so keep that in mind. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we've read the briefs and have discussed this case in conference. Counsel, you may proceed.
May it please the court, my name is Yvette Ansel and I'm representing the appellant cross appellee Robert Rubens. In this case, the 2017 decree found that an equal division of community property is appropriate to achieve equity. But the trial court provided an unequal division in a lot of its rulings. After the December 2000, and I'll start with the failure of the trial court to provide credits and offsets to, and I'll refer to appellant as husband and wife to make it easier. So after the December 2015 service of the petition, in order to avoid delinquent payments on some of the community assets, husband paid for a lot of those expenses without any kind of court order or without the court obligating him to pay for those assets. Wife could not point to any express agreement between the parties that husband would pay those expenses without any kind of equalization to him. In fact, the opposite is true. In the August 2016 stipulated order, both parties acknowledged that there was equalization of marital community and contributions toward community expenses or payments toward liabilities, and those equalizations would abide trial, and that's on page 3 of that stipulated order. Husband paid those community expenses because if he didn't, there would be community assets that would be dissipated or lost. Those payments were not gifts. As stated by the trial court in the Bobrow case that was cited in my opening brief, wife was obligated to prove by clear and convincing evidence that husband intended the payments for community expenses to be a gift. Wife failed to do so. Husband asked for a credit and offset in his pretrial. And even at trial, the court acknowledged that it would, quote, need to account for husband's sole and separate payments on community assets after the date of service. Now wife argues that those payments are unlike those in Bobrow because they were pursuant to Rule 69, but that is not the case. First, the only temporary spouse maintenance and payments toward the marital residence are addressed in that stipulated Rule 69. But not all of the other payments that husband was made toward community expenses were addressed. Second, the Rule 69 is dated months after the service of the petition. The Rule 69 acknowledges that there's no agreement as to whether husband will receive credit for the payments required under the Rule 69, so husband was free to request that credit. Wife argues that husband was able to pay the community obligations and therefore wife didn't have any income to pay them. So of course, they've been historically paid by husband. Of course, he was going to pay them. But Your Honors, that was the exact argument made in the Bobrow case. And I'm quoting from that case that husband made the payments to preserve community assets. Evidence is husband's intent was not altruistic, but to avoid adverse consequences. Ideally, all divorcing couples would work together toward a mutually agreeable resolution of a failed marriage. A spouse who voluntarily services community debt and maintains community assets with separate property should not be penalized when a mutual agreement cannot be reached. When such payments are made, they must be accounted for in an equitable property distribution. Wife's position is that her position is an inequitable division, which is in contradiction to the court's pronouncement that there should be an equal division in this case, which was stated in the decree. And the amount of the payments are for the trial court to address. While husband disputes that wife's position is that there was a decreased amount of spousal maintenance to adjust for payment of other community expenses. But the court in El Sharkawi, which I cited in my opening brief, quoted the court in Kolsch, stating that a decreased support obligation cannot justify an inequitable distribution of community debts. Awarding one spouse a lesser share of the debt as a substitute for spousal maintenance is contrary to the law. And that's what the trial court did in this instance, and that amounted to an abuse of discretion. I'll next turn to the reversible error regarding the order of the...
If you could clarify that one more time. I'm sorry to interrupt.
Sure.
You're saying the court can't factor in determining the award of spousal maintenance, can't factor in that one spouse has shouldered more of the community obligation?
No, what I'm saying is the court in the Sharkawi case, which is also quoting the court in Kolsch, specifically states that awarding one spouse a lesser share of the debt as a substitute for spousal maintenance is contrary to the law. So if there has to be an equal distribution, there has to be an equal distribution. You can't substitute the spousal maintenance. They're two separate issues going on. Spousal maintenance is one issue, the debt is another issue, and husband has to be the debt that husband has to pay has to be equalized in some sense if the court ordered that there was an equal distribution and division of debt. In terms of the error that the court committed for husband paying post-service debts over which he had no knowledge or control, those were the debts, the external debts related to the community business Wildvine. That was awarded to wife without any kind of equalization to husband. Pursuant to ARS 25214, spouses are supposed to have equal management control and disposition rights over their community property and have equal power to bind the community property. That didn't occur in this case. Also, the test of whether a debt is a community debt is whether it is intended to benefit the community. Again,
Just a moment. Did you just say that husband did not have access to the business and did not have authority to bind the business?
He didn't have access to the business, Your Honor. There was a order of protection that wife put on him a few months after the service of the petition, which kept him completely out of the business.
No, go ahead.
Is there some instance where he made a request for some information that was not provided?
Constantly, Your Honor. He constantly made requests for information. He wasn't provided with any financials of the business until July of 2017, which was right before the September trial of the case. So he was unaware of a large portion of the almost $209,000 debt that wife had incurred related to the business.
What was he aware of?
Well, he had a business attorney to try to be involved in the business, but he wasn't allowed anywhere near the business, and he couldn't contact wife about the business. So he tried, but he wasn't able to have any access to the business.
Go ahead.
Go ahead.
So all this debt incurred during the period of time that the court had him out and her in?
Not all of it, a large majority of it, Your Honor. I believe $209,000 was incurred, and a large majority of it was incurred without his knowledge and without his consent, yet the court ordered that both parties split that debt with proceeds from the sale of a marital residence.
Thank you.
And then when the business was finally awarded to wife, it was awarded at a zero value. So wife got a debt-free business as of December 2017, and husband was ordered to pay half of $209,000 of the debt of that business that mostly wife had incurred. And that is inequitable.
That assumes that the business is profitable going forward, is that?
Correct, Your Honor. It does assume that the business is profitable going forward. However,
And there's evidence to that effect, that it will be profitable going forward?
well, there wasn't evidence regarding that, but the business was awarded to wife debt-free as of December 2017, with husband paying half of.
But that's a different issue. So if it's a business that's not going to make any money, it doesn't, that's neither here nor there. And if there was a possibility that it was making money, that it was going to be making money during the marriage, they're both on the hook for the debts, it's hard to see an abuse of discretion.
Well, except, Your Honor, that the debts that husband had no part of, he would only be obligated to pay for the debts if it was for a community benefit. There was no community benefit for him. The only thing he got was paying over $100,000 of debt, while she got a debt-free business.
But if it's a community asset, I mean, doesn't that mean that you benefit when the business is doing well, and when the business is tanking, you both shoulder that responsibility?
If both are involved in the business, Your Honor.
So he wasn't legally responsible for the business because he wasn't allowed in the building?
No, he was legally responsible for the business and the debts of the business, but because of wife's actions, he wasn't allowed to be involved in the operation of the business.
Now, the Rule 69 agreement you've referenced says, husband may communicate directly with the bookkeeper for the business if he has questions or if wife does not timely supply the information. Did he communicate or attempt to communicate directly with the bookkeeper for the business?
I believe, Your Honor, that stipulated agreement was before the order of protection was put in place.
Well, the order of protection didn't involve the bookkeeper, did it?
Well, it didn't, and husband tried to get financials, and he wasn't able to get financials.
So husband did try to communicate with the bookkeeper?
Your Honor, I'm not aware. I wasn't trial counsel at that time, so I have to honestly tell you, I don't know if husband tried to communicate with the bookkeeper at that point.
Well, that's the crux of the thing, isn't it? Because in order to determine how a business is doing and how it's operating, it takes more than going physically to the premises, right? You would agree that
Correct.
You could have people standing room only, and that could be a fluke for one night. It could be a private event. I don't know. It could be a number of things. Or there could be no one there. And you can't really gauge how the business is doing just from showing up. I mean, you get a feel maybe, but not really until you look at the books, right?
Correct, Your Honor.
So that's what we would need to know. When you're saying he had no access to know how the business was doing, we would need to know, did the bookkeeper not communicate with him? Did he make efforts to communicate with the bookkeeper? And was that presented to the court?
There was a gentleman that they hired in order to view the business and to see what was wrong with it and what was going on and some improvements that were being made. So that was, I believe, something that he relied on in order to get the business going. But
then that's his issue with whoever he hired. If he hired someone who did not talk to the bookkeeper, he just probably hired the wrong person.
Well, they both hired this person, but I believe that person said that there were a lot of things that were going wrong that needed to be fixed.
So we just don't know if he made efforts to talk to the bookkeeper.
I cannot answer that question for you. I do know that he tried to be involved in the business. He certainly had absolutely no knowledge of the significant debt that was put on the business after the order of protection was put in place.
Is there anything in the record that reflects him making a request to the bookkeeper that was denied, or him following up with the court saying, I have not received something I've asked for from the bookkeeper. There's no order of protection involving the bookkeeper. Please tell the bookkeeper to give me this information. Can you point us to anything like that in the record?
I know that there were a lot of requests for information for the financials for the business, Your Honor, and that was brought up in the pretrial as well, because it was brought up that financials were never provided to husband until 2 months, less than 2 months before the actual trial. I also want to quickly address the issue of the court accepting wife's list of Exhibit B for the amount of the debts. And quickly I'll address that the court ruled that specific external debts of the business of Wildvine would be split between the parties. When wife provided an Exhibit B to a post-decree motion, the court just accepted that as Exhibit B as if it complied with what the court stated, which is external debts would be covered. However, unfortunately, Exhibit B also included operating expenses of the business, which the court in its decree did not say would be split between the parties. The court assumed that both of the parties agreed that Exhibit B was a list of what the debts were in compliance with the decree. It was not. That would add,
Just a moment. How do we know the court assumed that?
because the court stated that in its ruling in April of 2018. It said both parties agreed that these are the list of debts, so we're just going to go with that. And the court did not allow husband to respond or reply, actually, regarding that those whole series of pleadings. So the court was unaware that husband did not agree that that was the list of debts that was complied with the external debts ordered in the decree.
Okay, so when the court said that both parties agree that Exhibit B is the list of debts, did husband object?
He couldn't. The court didn't allow any kind of a response to that. So the court made its ruling prior to that when wife submitted an Exhibit B as part of
He couldn't
her.
lodge an objection?
The court wouldn't allow any more pleadings. It was specifically requested, and the court would not allow any more pleadings to that. So the court was unaware that husband disagreed.
Where?
Post-ruling, you can't file an objection to the ruling?
We couldn't. The court did not allow any more. And then the appeal, there was a notice of appeal. So that all came into play with the litigants not being able to let the trial court know what was going on.
What is the record that shows that he tried?
That husband tried? I believe
said
it's
that
it's
you
in one
tried.
of the pleadings, and I believe it's in our opening brief as well, Your Honor.
Well,
That
no,
there-
in the Superior Court.
I don't recall what's specifically in the Superior Court. It would be in my opening brief, though. There was a specific request to address that Exhibit B did not comply with the decree, and husband was not allowed to submit any kind of pleadings related to that. Quickly, I also want to address the mathematical error on the Fidelity account 2664 and Chase 9337. No matter how you try to figure it out, the court made specific findings on what was owed, both on Fidelity 2664 and Chase 9337. You can't make it work so that the court's imposition of $16,787 and 47 cents owed adds up in any manner whatsoever. Specifically, the court found that husband took $116,307 and wife took $114,225.30 from the Fidelity account 2664. Wife agreed, argued that same position. That results in husband taking $2,081.70 more than wife from that account. You split that in half because it's community funds. Husband would owe an equalization of half that amount, $1,040.85. The court also specifically found in the decree that Chase account ending in 9337 had an approximate value of $7,119 as of the date of the service. Each party is entitled to $3,559.50. That amounts to $4,635, not $16,787 in some sense. So the court miscalculated. There's no way to come up with the court's calculation of $16,000 and some $1,000. So it has to be reversed. Finally, actually not finally, but the 2016 tax refund issue. Originally, the court ordered that the tax refund would be awarded to husband in the decree because husband made all the income in 2016. And then specifically in April of 2018, the court stated that based on the parties' agreement, they would split that. There was no agreement. Specifically, the husband agreed that it would be split, it would go to both parties, but that it would be offset. There's specific citations in the trial court level, and even wife says that it would be subject to an offset. So there was a mistake on that hand as well. And in terms of the spousal maintenance argument, and I want to save a little bit time for my rebuttal, but if the court now shifted $52,000 to wife months after it decided spousal maintenance in December, it could not have considered all of the assets awarded to each party. So the spousal maintenance ruling has to be sent back because the shift of $52,000 taken away from husband and giving to wife of liquid assets that are not taxable is a significant consideration that the court couldn't have made because the ruling occurred months after its spousal maintenance argument. And I'll save the rest of my time for rebuttal.
And counsel, because there is a cross appeal, you may reserve a portion of your time for rebuttal to address only the cross appeal issues if you desire.
May it please the court, my name is Taylor Young and I represent Kimberly Rubens in this case. I'm going to endeavor to reserve 2 minutes for a rebuttal on the cross appeal. We'll see how that goes. The court's questions regarding the record I think are important in this case and sort of emblematic of one of the challenges of this appeal when it comes to appellee. And I would like to bring to the court's attention that much of this discussion about husband's access to records and being frozen out of the business came up for the first time in husband's reply brief, which caused wife to file a motion to strike or, in the alternative, a motion for surreply, because the reply brief contained 7 pages of quote-unquote additional facts to support the argument that wasn't facts that did not exist in the opening brief. The court deferred ruling on that motion to this panel. So it is before this panel, our motion to strike or for a surreply. And I would ask the court to consider that and look at it because the narrative that we're being presented here is not one that, frankly, we've been able to respond to in any kind of briefing. We do cite a couple of examples in our motion, but we don't want to push it. We can't turn our motion into the surreply that we haven't been given leave to file. So I'd ask the court to please take a look at that. And I would also point the court to the fact that these errors that are being presented in this case are all errors of discretion where husband just disagrees with the trial court's view of the evidence. In every single case, there is evidence to support the court's position in the decree, and husband just disagrees.
But shouldn't we be able to come up with numbers, though? I mean, just the simple division of bank accounts, for example. Can you point us to numbers that support the numbers the court concluded? Please?
So specifically on the mathematical issue, I would say that it's within the trial court's discretion to do the math the way the court did the math. I have not gone through and been able to. I can get close, but I can't get the specific number that the court.
How is there discretion in numbers when it's just if we're equally dividing bank accounts and these are the numbers? Seems like someone ought to be able to point to this is the value of this account, this is half of that account.
I understand that, Your Honor. I would say you're talking about issue number 6 in this case, and I would say that our position would be that in the entire balance, there's an equitable division in this case, and that nothing in that mathematical error has resulted in an inequity to husband. I would like to transition, though, and go back to an important point that was brought up regarding husband's argument that the Bobrow case prevents the trial court from looking at the Rule 69 agreement and looking at the spousal maintenance award and making adjustments based on that. I would point the court to the Barron case, Barron v. Barron, which is 246 Ares 580, in which this court addressed a Bobrow challenge, and the court specifically, in that case, specifically looked and said that the trial court had not used the gift presumption that was the issue in Bobro. And since he hadn't used this gift presumption, this presumption that payments made post-petition are a gift to the community, since he hadn't used that presumption, there was no error in that case. The court also, in looking at that case, noted that they weren't dealing with a post-nuptial petition, a post-nuptial agreement like we are now. And the court further said, given the financial disparity between husband and wife at the time, the Superior Court had discretion to retroactively grant temporary spousal maintenance. And the court cites there the family law rule that allows for a judgment to be entered nunc pro tunc. And so in this case, if it was determined that there was an error in not crediting post-petition payments that were made pursuant to this Rule 69 agreement, a Rule 69 agreement in which the temporary orders for wife were $3,000 a month, her ultimate spousal maintenance was $8,000 per month. The $3,000 a month was expressly conditioned on the agreement that husband was going to, not only husband's agreement that he was going to make these post-petition payments towards these community assets on these homes, but his insistence that he would do so. And so if the court were to decide that there was a legal error there, what you would end up in it being a non-prejudicial error, because the court could go back, the trial court could simply go back and retroactively adjust the spousal maintenance to account for the fact that fact that the parties made this agreement that she would receive $3,000 a month and husband would make these payments on these community assets. I'd also point out to the court that when it comes to these business debts, husband's complaint that these Exhibit 25 debts are somehow improper and improperly included is not availing and ignores the fact that one of the reasons why there were these debts on the business that ran up was husband's failure to abide by his temporary orders. He was held in contempt for it. It's the last paragraph in the decree holds him in contempt for failing to have abided by those temporary orders and paying $5,000 per month to support this business. The court asked some questions about whether or not this is a business to be profitable. You can look no further than the decree to find this language from Judge Hopkins. He says that this is a business that has historically hemorrhaged money. And he says that this is a business that will be an albatross around the neck of whomever he gives it to. He also has a specific finding that husband does not have the temperament to run this business, and that husband's business plan for this business was not a good one. So wife did get a business that was valued at $0. That valuation, frankly, was generous, given what she got.
She can presumably walk away from it.
Well, once the debts are paid, and by the way, the debts, what husband didn't inform the court of, is that these debts that were paid for the business, those were paid first by selling the marital residence, which was the residence that wife was living in at the time. She abided by the court's order. She sold the marital residence, and those monies went to pay off these debts first, community debt to pay off, and then there's an equalization after that where the parties have to pay these debts. And Judge Hopkins knew all of this. He was familiar with the case. We had a 3-day trial, which is sort of remarkable in Maricopa County, frankly. He was well aware of the facts and decided these issues well within his discretion. I'd like to circle back one thing before I lose it. The husband points to this order of protection that locked him out of the business, and I would just like to point out to the court that the reason why this order of protection was sought by wife was because husband was threatening to lock her out of the business. And so this is not a situation, and this is one of the reasons, this is something that we would address in our SIR reply if we got one. But the one-sided presentation of facts in this case, which comes in husband's reply brief, paints a distorted view of the record. And frankly, we didn't go into the full amount of detail because we didn't have anything to refute given what was in the opening brief. I mean, husband just cited to no facts in the opening brief. The opening brief cites to husband's position cites to his pretrial statement in which he says his position is that he's entitled to credit for these debts, and testimony. And the testimony, it's my position that I'm entitled to debts, or I'm entitled to these, to credit for these payments, and that's
Did
it.
husband make a request to receive information specifically from the bookkeeper?
He had access to it. I don't recall from the record how many requests were made, but he had access to the bookkeeper throughout, and we point out in our in our motion to strike, or for reply, we point out all the places where there was testimony that wife testified that she gave him records, that he had access to those records. There's more that we could say, but again, we hadn't had a chance to do that in the briefing. I'd like to let me look at my notes real quick. I just want to, before I transition to our cross appeal. I did want to, I'm sorry, I did want to address one argument. Husband argues that ARS 25214 means that the debts that were incurred post-petition could not be allocated to him as part of community debts because 214 requires both spouses to sign in order to bind the community. But I would just like to point out to the court that we're not talking about a wife entering into new guarantees or new loans on behalf of the community. We're talking about the community business continuing to be operated during the course of the divorce proceedings. And the ordinary operation of business and the debts that are just incurred as part of that ordinary operation of the business, these are the business's debts. This isn't wife incurring these debts on behalf of the community. It's the community business incurring debts so that it can continue to operate throughout the divorce. And Judge Hopkins had access to all that information as well. So 214 is just not a basis on which the court can reverse Judge Hopkins on that issue. One of the things that we pointed out in our answering brief was that husband's issues are all issues of discretion where they're disputed issues of fact. Obviously, we could have raised issues that we thought Judge Hopkins, should have seen the evidence our way. We didn't, but we do have one issue that we have raised on cross appeal, and that is the valuation of the Red Cliff property. It's one of the properties that was awarded to husband. At trial, wife objected to use of an expert appraisal at trial because the expert witness was not there to lay foundation and not there to be cross-examined.
Were there other appraisals that were used?
There were other appraisals in the case, but the appraisal that was exclusively relied upon was this appraisal, and the court's ruling is clear that he used that number per exhibit. It's called Exhibit 5, which is this appraisal, that he finds the value of the Red Cliff property to be $442,000 per Exhibit 5.
But were there objections to the use of other appraisals or the presentation?
No, there was a joint appraisal, jointly paid for appraisal of $500 that came up with $555,000, and that was uncontested. That appraisal was admitted. It was before the court. Husband testified. Husband's position in his pretrial statement and what he testified to was that the property should be valued at $500,000. But there was also an email. It's Exhibit 301 in the case. There was an email from husband showing that he was attempting to sell that property for $620,000. So what we have here is an expert appraisal that we objected to. The other side argues that husband argues that, well, you didn't invoke Rule 2, so the fact that this was admitted and given the weight it was, it deserved, means that you can't, that you don't have error here. But husband's wrong. We did invoke Rule 2. We cited to it in the record, the invocation of Rule 2. And in fact, the trial court expressly stated that he had found and seen that Rule 2 had been invoked, but that he thought that he could still give the evidence the weight it deserved and be liberal in admitting this. And
And where in the record is that?
sure, Your Honor, the Rule 2 notice is index of record number 12. The court acknowledged the Rule 2 in the transcript of 926, which is day 1, at page 138. So that's where the court acknowledged that, yes, there was a Rule 2 notice here, but he said that he thought he could give the evidence the weight it deserved. Unfortunately, as we noted in our reply brief, there is a case, it's not a binding, but a MEM case, a MEM decision from this court, in which the court has rejected that argument and specifically noted that you can't have an expert witness's testimony admitted through a non-expert. Arizona Rule of Evidence 703 will allow for an expert witness's report to be admitted by another expert when another expert is testifying, saying that they relied on that report. But that's not what happened here, and that's not what happened in that case. That case is called Krieger versus Dwick, and it's cited in our reply brief, but it's available at 2015 Westlaw WL 246878. And that case is very analogous. In that case, you had a custody evaluator's report, and the custody evaluator did not testify, but the father testified. The custody evaluator's report was entered into the record through father's testimony. And this court, in an opinion by Judge Kessler, said you can't do that. And the court, in that case, the court specifically said that that father is not an expert, Rule 703 doesn't apply to him, and the court can't simply just give this opinion the weight that it wants to. And what Judge Kessler cited there was the Gaston versus Hunter case, which is 121 Ayers 33, where this court said when an evidence has been admitted for a purpose, when an evidence is inadmissible for the purpose it was offered, it can't be relied upon even if it might have been admissible under another purpose. And so in this case, we have an expert appraisal. We raised the objection. The objection was in our was made before trial. They knew the foundation, and when the court overruled our objection, the court simply said, you could have deposed him, but you didn't depose him. And that's not that it wasn't our requirement. These family law cases, as you know, can get very expensive. We made a foundation objection. It's their obligation to present their experts so that we can testify, or so that we can cross-examine him regarding his foundation. He wasn't there. In our brief, we also cite how prejudicial this was by pointing to testimony that was offered by a wife who's a former real estate agent regarding the problems with this very appraisal, that it was a more narrow appraisal, was specifically limited, and that it didn't include all the comps that should have been there. Now, the fact that wife presented direct testimony of that is not the same as her attorney cross-examining the expert appraisal on that. And lastly, I would point out that I know Judge Catani asked, were there other appraisals? And I also wanted to point out that not only did the court specifically state that it was relying on this appraisal, but this is a case where we had requested findings of fact and conclusions of law. And so you have to take the court at its word that this is the appraisal that it used. And so its reliance on this appraisal, which caused prejudice to us to the tune of many, many, many thousands of dollars, requires reversal. I'd like to reserve the last minute and a half for rebuttal, if I may. Thank you.
Your Honors, just briefly regarding the rebuttal, because I know that opposing counsel has addressed that there would be an equitable distribution of community property. In the decree on page 5, the court specifically found that there would be an equal division of community property, and that's where all of this goes a little bit awry. In terms of the cross appeal, wife mistakenly states that the trial court relied singularly on this Exhibit 5. That is not the case. It's debunked by the trial court itself. In its ruling on April 27th, 2018, the trial court specifically stated that it determined value based on, quote, all the evidence, which included husband's testimony and was not specifically just based on Exhibit 5. The court specifically rejected the higher valuation on an appraisal that was submitted by husband only to show the deficiencies in that appraisal, but there was no expert regarding admitting that as well. The court specifically rejected splitting the
Counsel?
difference between the two.
Time's up.
Thank you, Your Honor.
Thank you.
Thank you, Your Honors.
Very quickly, I would point the court to the decree on page 9, which says, and I'm quoting, on the issue of value of the property referred to as the Red Cliff property, the court finds the value of this property to be $442,000 per Exhibit 5. Statements that the court relied upon all the evidence, courts state that they relied upon all the evidence all the time. But again, if this exhibit hasn't been, shouldn't have been entered, if his opinion wasn't admissible, then you can't find other evidence that would support a valuation. The next closest piece of evidence is husband's own testimony, that $500,000 of value. The next piece of evidence is the Exhibit 201, which was the joint appraisal, which was $555,000. The next piece of evidence is the email from husband seeking to sell the property at $620,000. So there's just no way that we can get to a valuation down and reach this number, particularly where findings of fact and conclusions of law were requested, and the court says that it is finding the value to be $442 per Exhibit 5. We have to trust the court on that, and for that reason, we have to reverse. Thank you.
Thank you, counsel, for your arguments. This matter is now under advisement, and we will issue a written ruling in due course. We'll now take a brief recess to prepare the courtroom for the next oral argument.